we were we were waiting yesterday for the judge's order. We were watching Sarah Boone's Interrogation. You guys haven't watched it yet? That was posted yesterday. So we were waiting for the judge's order. It didn't come in, but now it is finally in. He finally has his written order in regards to the motion to suppress the 2-hour interrogation video, which when we watched it yesterday, we realized it really did look super bad for Sarah Boone. I mean, I knew it looked bad for Sarah Boone, but damn, it looks so bad for Sarah Boone. And then there was also the other issues in regards to the restraints. And actually, you know what? I don't know if the written order for the protective order is out. That one might not be out yet. Well, let me read through it and then we'll see. But let's start with the first one. I was going to do a live stream, but I was like, I got a lot of stuff I got to do today. So I'm sorry, guys, we're not doing a live stream. I'm just going to read it to you guys. Let's do a quick little discussion about it. All right, Judge Kranick. Let's see what he has here. I have not read this, by the way. I have not read it. Order on defendant's motion for the right to hair, cosmetics, and civilian clothing without restraints for trial. So the one that we're really going to be focusing on is the restraints. A, the court provided an ora tennis, don't unpronounce that, ruling on October 3rd, 2024 regarding defendant appearing in civilian clothing for trial and defendant's access to cosmetics and hairstyling throughout the trial. B, the court reserved ruling on defendants appearing before the jury free from physical restraints. C, in deciding whether to physically restrain a defendant and what method to use, the court must balance its obligation to maintain courtroom safety against the risk that the security measures may impair the defendant's presumption of innocence. See Diaz v. State. D, a court may order physical restraints only if it is found to be necessary to maintain the security of the room. Before ordering a defendant shackled at trial, the trial court must make a case-specific and individualized assessment that considers 1. Defendant's criminal history and the nature of the pending charges with the special attention to whether either involve violent acts. 2. Whether the defendant has disrupted criminal proceedings in the past. 3. Whether the defendant has engaged in a threatening behavior. See Carlisle v. State. You guys remember there was one of the hearing that happened when Sarah Boone was still pro se, and one of the deputies at the... Was it a deputy? I think it was like a deputy at the jailhouse where she's at, went up there and testified and was like, hey, we don't think that, we should get rid of the restraints from her because if you look at her past history, she has an issue with compliance. And then Sarah Boone, being pro se, was asking the questions back and forth and was like, oh, what are you talking about? When was I not complying? And he was like, oh, when you didn't want to do this, when you didn't want to do that, you didn't want to show up for a court hearing, you didn't want to, do whatever. And so there's some back and forth there. Now, if you guys don't remember that, this should be one of our videos in our Sarah Boone playlist. Okay, so, honestly, I think it'll just be like, maybe just have her do like the leg shackles, but then just have her be hands-free. It seems like that was where they were going to go with in the hearing that happened 2 days ago. E, there was no evidence that the defendant has any criminal history. F, defendant is charged by the way information filed 03/23/2020 with a single count of second-degree murder. G, there's no evidence the defendant has disrupted criminal proceedings in the past or has been a contumacious. What now? I do a lot of reading. I usually know these words, but contumacious. I've never actually seen this word before. Contumacious. All right, we learned, y'all. Contumacious. Especially of a defendant's behavior, stubbornly or willfully disobedient to authority. Okay. All right. Contumacious. We learned a new word. Let's try to use contumacious today, y'all. There was no evidence the defendant has disrupted criminal proceedings in the past or has been contumacious defendant during the court proceedings. H, no evidence the defendant has engaged in any threatening behaviors. Order and adjudges as follow. The motion is hereby granted. Defendant's shackles and handcuffs, can be removed during the trial proceedings. So I guess she'll be free with her legs and hand-free as well. Okay. Honestly, I don't really have any issues with that. I don't think we'll be expecting a Taylor Swift business from Sarah Boone. You never know. But so far, seems okay to me. All right. Now, this is the one that I really was looking forward to reading. This was the motion to suppress. The stuff at the Orange County Sheriff's Office. A, defendant Sarah Boone is charged by with a single count of second-degree murder. On February 24th, 2020, defendant called 911 after finding her boyfriend, George Torres, deceased. C, Deputy Kayla Rodriguez arrived on February 24th, 2020, spoke to the defendant. He also states Exhibit 1. D, Detective Kepsel, the one who testified 2 days ago, a homicide detective with the Orange County Sheriff's Office with 6 years experience as a homicide detective and a law enforcement officer since 2013, was the lead investigator of George Torres' death on 24th of February 2020. Detective Capsule arrived at the scene within 30 minutes to an hour of Orange County Sheriff's Office deputies arriving, was briefed, performed a walkthrough of the apartment. Therefore, a search warrant was drafted. Detective Capsule then made contact with the defendant outside of the apartment for a few minutes and explained procedures of the search warrant. The search warrant was executed with CSI. Defendant's cell phone was collected after CSI documented the scene. Now remember, there are two different versions of the events that we heard from. Detective Capsule testified in the stand, and so did Sarah Boone. Detective Capsule was like, well, I got to Sarah Boone's phone. I did it through the proper procedures, right? It wasn't until that she signed the waiver, do we get the phone, and then I gave it to the cell phone person, and they extracted the data and stuff like that. Sarah Boone was like, no, she kind of came up to me and was like, where's your cell phone? And then she showed up with the cell phone, and then she asked me to put the PIN number in. I put it in, and then she disappeared with it for a little bit. So two different versions of events. Sorry, sometimes my mouth talks a little too fast. My brain is like, sorry, it's a me thing. Okay, it's a me thing. Just ignore me. It's a Corgi thing. Defendant signed a consent prior to the February 24, 2020 interviews addressed below. Detective Capsule did not look at the defendant's phone, including any videos prior to the interviews addressed below, as digital forensic did not arrive until approximately 7 p.m. Detective Capsule then made contact with defendant's ex-husband, Brian Boone. Thereafter, Detectives Capsule and Lowen had an interview with the defendant in Detective Capsule's unmarked Nissan Pathfinder at approximately 5 p.m. Detective Capsule explained that she wanted to have conversation with the defendant after walking the apartment. Detective Capsule testified that she would not have interviewed the defendant outside of an unmarked vehicle, had no memory of using the words routine, and that everything was explained on the recording. The word routine was not used by Detective Capsule in any recording. Detective Capsule explained the purpose of the interview, including the defendant's prior conversation with Deputy Kayla Rodriguez and Detective Capsule's desire to get a further understanding of what happened last night, and asked the defendant for more details. Thereafter, Detective Capsule began reading Miranda as follow. Detective Capsule: I'm going to read you your rights, but it's just because that's how we do things, okay? So you do have the right to remain silent, okay? Do you understand that? A little notation here. All 8 questions on Detective Capsule's Miranda card were read, as Detective Capsule did not have question number 9. Defendant: yes. Detective Capsule: anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? Defendant: no. Detective Capsule: do you understand what I just read to you? Defendant: yes. Thereafter, Detective Capsule interviewed defendant again after the initial digital recorder's memory was full. A second separate recording was initiated. Detective Capsule confirmed with the defendant that no additional communications occurred prior to the second separate recording, and Detective Capsule inquired of the defendant prior to asking any other questions, in quotations. You do understand that you don't have to speak to me if you don't want to, correct? To which the defendant responded, yes. After concluding the interviews before leaving, Detective Capsule had conversations with the detective, Detective K had a conversation with defendant about coming to Orange County Sheriff's Office the next day to address the pending autopsy, and Detective K would have more questions. I'm actually surprised they were able to get George's autopsy pretty quickly. I feel like sometimes autopsy takes a bit, right? I know toxicology can definitely take months, unless you want to speed it up a little bit. But it was good that they were able to get George's autopsy done pretty quickly. Detective Capsule did not recall speaking about the defendant's cell phone, but had defendant asked about getting the cell phone back, Detective Capsule would not have given a specific time frame for returning the defendant's cell phone. Detective Capsule had no memory of receiving a call from the defendant on the evening of February 24th, 2020. That was where Sarah Boone said that she took Brian Boone's phone and called Detective Capsule. And Detective Capsule was like, this is from Sarah Boone's perspective, that Detective Capsule was like, oh, hey, like, you want to come get your phone? Like, come to like Orange County because I'm pregnant and it would just be a lot better if you were just there. Detective K said that she didn't really remember that conversation. And then she asked James Owens, like, do you have like a record of that phone call or anything like that? He didn't confront her with one. Defendant's testimony largely agree with Detective K's testimony, including the timeline of calling 911, speaking with Deputy Kayla Rodriguez, and speaking with Detective Kepsel. As to the February 24, 2020 interviews, defendant confirmed that Detective K explained that general questions would be asked. There's a little notation here. During the second separate recording, defendant used higher tier words, including compos mentis. Sarah Boone did? Compos mentis, having full control of one's mind. Oh, is that where I thought she was saying cattywampus? Was she really saying compos mentis? Because I was like, did she really say cattywampus? Defendant confirmed that she stayed on the scene for 10 plus hours while the investigation was performed. Defendant's own testimony was that she was under the influence of alcohol from the night before at approximately 10 p.m. the next day. However, there was nothing evidencing defendant being intoxicated or under influence of alcohol when clearly speaking and interacting with Deputy Kayla Rodriguez. J, defendant's statement of making a call to Detective K between 9:30 p.m. and 10 o'clock on February 24, 2020 from her ex-husband's home does not line up with defendant's own timeline of staying at the scene for 10 plus hours, which began at approximately 1 p.m. The court finds his statement lacks credibility. I mean, they can just go through Brian Boone's cell phone records. Oh, but it's been like 5+ years, man. I don't know if those cell phone records even exist anymore. They must have Brian Boone's cell phone records, right? Because they would show Sarah Boone calling Brian Boone in order to assist her when George's body was found. Maybe they do have the records. Okay, defendant claimed that before they left the scene, detectives Kepsel or Lowen would return defendant's phone to the apartment. On February 25th, defendant claims that defendant and Detective Kepsel had a conversation regarding the picking up of the defendant's cell phone. Specifically, that due to Detective Kepsel's pregnancy, defendant needed to come down to Orange County Sheriff's Office to pick up the cell phone. Defendant's sole reason for traveling to Orange County Sheriff's Office was to pick up the cell phone. The court finds the defendants regarding picking up the cell phone also lacks credibility. L. On February 25th, 2020, after Detective Kepsel reviewed some of the extraction of the defendant's cell phone by digital forensic and attended the autopsy, Detective Kepsel requested the defendant to come to Orange County Sheriff's Office. Detective Kepsel did not want to approach the defendant in front of her child at her ex-husband's home. Defendant's worry and concern about her son was addressed with Deputy Caleb Rodriguez. M. The state and the defense agreed that February 25th, 2020 interview was custodial, right? Owens was trying to argue about like this was, a custodial thing. And the state was like, yeah, we're not debating that it was a custodial interrogation. We concede and agree with you, Mr. Owens. N. The pith of defendant's argument is contained in this exchange during the beginning of the February 25th, 2020 interview. Detective Kepsel. Just let us know if you have any time you need water, okay? I'm going to have you sit in the green chair. Appreciate you coming in. A little footnote. Approximately 1 hour, 27 minutes into the February 25th interview, defendant returns to her list of pre-prepared written questions and specifically asks, am I getting my phone back? This pre-prepared written question, would not be asked if one was told to come pick up the cell phone. Yeah, maybe. The defendant, yes, ma'am, I want to ask you about these when we have a moment, referring to her pre-prepared written questions. Detective Kepsel, sure. So obviously he received his autopsy. So I'm going to read you your rights again because we have to talk about that. And since I'm talking about the incident, we just have to do it, just like we did yesterday. Defendant, normal protocol? Detective Kepsel, just like we did yesterday, remember, I read you through the rights. Defendant, yes. Detective, yeah, it's the exact same thing, but since I'm asking you a follow-up question, I need to read them to you, okay? Defendant, sure. Detective, all right, so you have a right to remain silent. Anything you say may be used against you in court. You have a right to talk to a lawyer before and during questioning without charge. You cannot afford a lawyer and want one. One can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? Defendant, no. The court notes, this is a footnote, that the statement is an accurate statement of law, right v. state. While Detective Strope said, "This is something I have to do when giving the Miranda warning, this is an accurate statement of the law, as law enforcement officers are required to administer Miranda warnings prior to custodial interrogation." Detective Capsule, "And do you understand what I just read to you?" Defendant, "Yes." Okay, see State's Exhibit number 1. Whether the Miranda warning was sufficient. I mean, they kind of went through this already in the hearing. The judge was saying that as long as the 4 things was, given to the suspect before they did the interrogation, then it's all good. Whether the statements were coerced, it seems like she spoke pretty freely and willingly. Whether the statements were made voluntarily, I mean, she came in, she had a pre-list of questions that she wanted to give to or ask the defendant. I mean, I guess we can just, I don't mind reading it actually. All right, the motion, the amended motion, and the second amended motion, damn, all 3 denied. You know what? Let's just read it. If you guys want to stick around and listen to this, feel free. Number 1, whether the Miranda warning was sufficient. The Fifth Amendment of the U.S. Constitution and Article 1, Section 9 of the Florida Constitution both provide for a right against self-incrimination. The right self-incrimination clause of Article 1, Section 9, Florida Constitution requires that prior to custodial interrogation in Florida, suspects must be told that they have a right to remain silent. Anything they say will be used against them in court, and they have a right to a lawyer's help, and that if they cannot pay for one will be appointed to them. Trailer v. State. That was read aloud to Sarah Boone. P. Both the Florida Supreme Court and the United States Supreme Court have stressed that there is not a talismanic incantation required to ensure Miranda warnings are sufficiently conveyed. Miller v. State. A court does not examine a Miranda warning as if construing a will or defining the terms of an easement. Rather, the inquiry is simply whether the warnings reasonably convey to a suspect his rights are required by Miranda. So that 9th question there, where Mr. Owens is like, what was the 9th question again? It was like, do you understand what I'm saying, and do you want to continue speaking with me? The judge is saying that the Miranda was already read. It was done correctly. You don't need the 9th question. Even as part of the policy and procedures of the Orange County Sheriff's Office, it doesn't matter. We're going to go by what the case law says. The crucial task for determining whether the police gave a proper warning is whether the words and the context used, considering the age, background, intelligence of the individual being interrogated, impart a clear and understandable warning of all of his rights. Coyote v. United States. Q. The Miranda warning provided by law enforcement to the defendant at the beginning of the February 25th interview is sufficient both under federal law and Florida law. R. The Miranda warning given to the defendant in the instant case is identical to the exemplary Miranda warning identified in Owens, Supra. S. As such, the Miranda warning given to the defendant in this case was sufficient. All right. 2. Whether the defendant's statements were coerced during that course. I can't read that word either. Coerce. Because I feel like coerce. Shush. T. To establish that a statement is involuntary, there must be the finding of coercive police conduct. Baker v. State. Generally, to determine whether the confession is voluntary and coerced, a court must examine the totality of the circumstances surrounding it. Martin v. State. Whether the voluntariness of a confession is in dispute, it is the state's burden to prove voluntariness by a preponderance of the evidence. Harold v. State. U. There was no misrepresentations of the law regarding any defense. No quid pro quo. No directly or specifically made promises. No overt act or threat of force against the defendant was proved or claimed. No fear of material or physical harm. So like quid pro quo would be like, if you do something for me, I'll do something for you type of thing. No hope of material reward. No indication the defendant was a newcomer to the law based on the 2 times Miranda warnings were provided between February 24th and February 25th. Oh my gosh, Cheryl, are you okay? He's breathing. No indication the defendant is mentally deficient, especially concerning the verbiage she used. No threats, delusions, deceptions, or promises. And defendant was offered water and breaks. V. There were no false statements made by law enforcement in order to coerce the defendant to go to Orange County Sheriff's Office on February 25th based on the findings above. W. Under the totality of the circumstances, the defendant's statements on February 25th, 2020 were not coerced. 3. Whether the defendant's statements on February 25th were voluntarily made. X. A statement is not compelled within the meaning of the state or federal law if an individual voluntarily, knowingly, intelligently waives his constitutional privilege. See Miranda v. Arizona. The state must prove by the preponderance of the evidence that a defendant's Miranda rights were waived, Barger v. State. To constitute a voluntary waiver, the state must show 1. The waiver was a result of a free choice on the part of the defendant and not the product of intimidation, coercion, or deception. 2. The waiver was made with a full awareness of the nature of the right being abandoned and the consequences of the abandonment. Only if the totality of the circumstances surrounding the interrogation reveals both an uncoerced choice and the requisite level of comprehension may a court properly conclude that Miranda rights have been waived. Why? Factors relevant to consider include 1. The manner in which the Miranda rights were administered, including any cajoling or trickery. Cajole is like, cajole. Fuck, I know what cajole means. When you're trying to cajole someone. Isn't cajole just kind of like another word for trickery? When you're trying to like convince someone? Let me see. Persuade someone to do something by sustained coaxing or flattery. Persuade. To get around, to maneuver, to talk to coax. Okay. See Miranda. The suspect's age, experience, background, intelligence. 3. The fact that the questioning took place in the station house. See Drake v. State. 4. The fact that the interrogators did not secure a written waiver of the Miranda rights on the offset. Z. The Miranda rights were administered in a normal tone, cadence. There was no rush or urgent speech. See Chafin v. State. There was no delay in the administration of the defendant's Miranda rights. The recorded February 25th, 2020 interview reflects that the defendant understood and acknowledged that she understood her rights. Defendant acknowledged that she understood her rights. Evidence supported conclusion that defendant voluntarily waived right to remain silent and obtain counsel when officer read defendant has his rights and asked defendant whether he understood each of his rights, to which the defendant responded affirmatively. AA. The court reincorporates its finding in UNV. How do I read this? This is like feeling I'm reading music right now. It's like paragraph U and paragraph V. Herein, which shows further no cajoling or trickery. B. Defendant was 42 years old at the time she made the statement and appears to be of normal intelligence. C. The February 25th interview did take place at the Orange County Sheriff's Office and no written waiver was secured. D. Under the totality of the circumstances, defendant's statements on February 25th were made voluntarily, knowingly, and intelligent waiver, and this waiver was a result of a free choice on the part of the defendant and was not the product of the intimidation, coercion, deception, and that the waiver was made with full awareness of the nature of the rights being abandoned. Oh man, lots of motions denied for the defense. Now let's see what happens when the states, when they put in the motion in limine for excluding the battered spouse defense. Reminder again, they had an expert to examine Sarah Boone, and the state said that based on that examination, they're going to fight for excluding battered spouse defense. So that'll be very interesting. And it seems like the judge said that he was going to address that Monday morning before they start with the jury selection. Here's my question, though. In Florida, if anyone knows, do they typically start jury selection and then let's say they get their group of people? Would they do their opening statements that same day? Or would they just start fresh the next day? Because I guess to me, it would make more sense if everyone's already there. If it's just like, okay, well, we already have the people. The attorneys are here. The court people are all here. Everyone's here. Well, let's just do opening statements right away. Or is it normal practice for them to be like, okay, well, we did jury selection. Let's do opening statements the next day. I guess I could just email the clerk of court. Maybe just ask them. Because that's what I want to know. I want to know if jury selection and opening statements will be on the same day. All right, y'all. So that is the decision of Judge Kranick. He has denied Sarah Boone the motion to suppress. However, he did grant Sarah Boone to be free of shackles. So I think like leg shackles and handcuffs during trial. They already talked about the hair and makeup thing. I mean, mostly they addressed the makeup thing. It seems like no for makeup, too much of a headache, especially for the jailhouse because, you know, they don't want to have to deal with makeup on her face, the contraband. That's what it's considered as. And they're just like, yeah, no, let's just not deal with that. But, you know, I actually found a really cute hairstyle that Sarah Boone could do for short hair. Was it you guys that showed it to me? Where is it? I was like, oh, this could actually look kind of cute. But anyways, I think she looks fine. I think her hair looks fine. I think her hair and her makeup looks fine. Just put her in something decent, and I think she'll be okay, but not okay in terms of, they're gonna quit her, but okay as in, like, she'll get a fair trial. They'll see her, but then they'll see the interrogation, the body cam, and they'll be like, oh, wait a second, is this the real Sarah Boone? Anyways, that's about it for today. I hope you guys have a good, happy Friday. I'm sorry I didn't live stream this. I gotta pop out. Have a good one. Take care, and I will see you guys probably next Monday, because when they address the motion in limine, I mean, I'm gonna keep refreshing this to see when the state puts in their the motion in limine, and we'll cover that. All right, guys, have a good week and take care. Join the Discord, you guys haven't already, and have a good one. I'll see you guys. Bye.